Hello, ladies and gentlemen, and welcome to the ASA webinar, What Changes to California's Lien Law Mean for Subcontractors? Thank you for participating today. This webinar is part of a series of webinars sponsored by Bay Area Chapter ASA, ASA LA Orange County Inland Empire, ASA Capital City, ASA California, ASA San Diego County Chapter, and the Redwood Empire Chapter of ASA. Please note that today's program is being recorded. If you have questions during the program, please use the chat function to ask any questions of the presenter. Today's presenter is Dan McLennan. He is the ASA of California Government Relations Chair. He has more than 25 years of experience representing subcontractors, suppliers, and other firms in cases involving indemnity insurance, mechanics liens, and other matters, resulting in the resolution of hundreds of cases through mediation, arbitration, and trial. He's been awarded Martindale-Hubbell's AV rating, the highest rating in legal ability and ethics, and is we're happy to say, a frequent author and speaker for ASA and other construction industry trade associations. His firm is McLennan Law Corporation in San Francisco, and we are pleased to have him had presented this webinar series, including today's final of the three-part series. Welcome, Dan.
Okay, thank you, David, and welcome everybody. Good to see so many same faces over and over again. I'm flattered by that, and I'm glad to see that I haven't scared you away. And as we have in the past, we're going to try to go pretty quickly. This material, unfortunately, doesn't lend itself very well to just a webinar format like this because it's really depending so much on the new forms. And I'm going to present some of the forms here on the screen today. You may see, you may be able to see down at the bottom of the screen here the remnant of a form. We're going to be switching back and forth from the slide presentation to the forms, and hopefully you've all gotten an email or a download of the different forms. I tried to give it to you in a couple of different formats. One is a PDF portfolio that has all the forms embedded in it, and you double-click on the forms within the portfolio and they'll pop up. All the forms that we've presented are in Word format so that to make it easy for you to modify and use in your own practices. The other way that you can access these forms is from the executive summary that I hope that you folks have gotten, and there's live links in the executive summary to each of the forms that are residing in my website. You could also go to the website, find the executive summary there, and click on any of the links there. Now, I'm going to tell you that the real value for you in being in this seminar today is the forms. And so what I'm going to do in the slide presentation is give you an overview of the changes in the law and where some of the forms are impacted. We'll look at some of the changes. We'll try to give you a good concept of how the lien laws and stop notices and payment bond laws work together. But this really is better suited for like a 3-hour workshop where you could ask me all of your questions and we could really dig out some of the details in the forms. What I'm going to ask you to do is go ahead and use your chat function for quickie questions about a particular form or slide as we go along. But if there's anything that's going to take any real detail to discuss, probably the better thing to do is give me a call afterward. I'm happy to talk with anybody about this. You could shoot me an email and we can discuss it that way, but probably most efficient would be to have a telephone call after the fact. Okay, let's go. This is about me. I've added a little mugshot for you. I know it's kind of weird to just have this voice coming through your computer or your telephone, and so I thought I'd give you a little photo so you could put a face. I'm not going to comment on that face, but a face to know where that voice is coming from. Oops. Let's go back. Now, there's a link on my website to the executive summary of changes to the California lien law. This is a live link in my show here, so if you have the slides, you should have a live link there. Otherwise, it's blog page number 1317 on my website. So if you haven't been able to pull it up heretofore, you can go there and grab it right now if you want to play with that as I talk. Otherwise, you'll have it for later reference. There's 22 forms that are presented in the package of materials that you've been given, along with an index of the different names of the forms. All right, by way of overview, the sweeping lien law changes came about in September of 2010. Governor Brown signed SB 189. And this was 10 years in the making by the Law Review Commission. It's a consortium of ivory tower law school professors and some practitioners, and they felt like the lien law is complicated and it's scattered, and we need to make it more accessible to people and make it easier to understand. And they felt that some of the language was archaic, and so they wanted to clean up the language and make it more consistent internally and with practices in the area. And so they got together and crafted 235 single-spaced pages of this bill, SB 189. 235 pages. And yes, I have read the entire thing. I participated with 6 other lawyers affiliated with the American Subcontractors of Association of California, and we vetted the bill, picked it apart into separate sections, and commented to each other and vetted the bill together as a group. It was an enormous process, and thankfully the Law Review Commission and the author listened to us, and they made a lot of changes in the bill before it got to Governor Brown based on the comments that came out of our work group. The overview by the commission was, well, we're just wanting to repackage it, clean it up, and make it accessible. We're not really making substantive changes. However, as you'll see as we go along, they really did. Sometimes they intended to make substantive changes, and sometimes they didn't intend it, but actually did make substantive changes. There was another bill that followed, SB 190, that was signed in June of last year, and it had some cleanups of SB 189. Even after we vetted it and the commission vetted it, there were a number of problems that still existed in the bill, and we got that cleaned up. And there's still some problems. As you're going to see, there's one in particular about a service issue that has to be cleaned up, as that may actually impact how you do your liens services. We'll talk about that as we get there. Okay, here's from the bill, Section 107. It tells you where the substantive changes are. Let me see. I'm not sure if you can see my pointer. Let me see if I can get you a better. There we go. Substantive changes. The act is intended not to be substantive in effect, is the primary statement, but these sections, they acknowledge that they are making substantive changes too. And then we've given up, they say, we're not using former sections of the law because they've been superseded or incorporated elsewhere in these sections or rendered obsolete because of these other changes that have been made. This is in the bill itself. If you want a list of the sections that have changes, substantive changes, they're listed there in the bill. Ooh. Okay. Still an overview. The intent was to make the laws accessible, and it's all found in the California Civil Code now, the lien laws. And here's the site to where you can find the law in the California legislature. Now what I'm going to do here is show you, let's go to the next page. Oops. I'll show you the Civil Code in a section, and in a second and show you how it sections out. But the general changes are they repealed the entire old law and recast it into civil code groupings. We have a general section that applies to works of improvement generally. That's the 8,000 through 8154. And then the next section is 8160 to 8848, and that deals with private works of improvement. So this 8,000 to 8154 applies to anything, public or private. And then 8160 to 8848 is just private. And then lastly, section 9,000 to 9566, that's the very last section, is for public works of improvement. And here's how it looks in the index in the Civil Code. And here's the index in the Civil Code here. You'll get the slide, but let me show you how this works. In Part 6, this Part 6 is entirely new and added by SB 189. And here's Title 1, that's the General Works of Improvement application, Section 8,000 to 8154. Then Title 2 is for private, 8160 through 8848. And then your public, I don't know why I got blue here and purple there, but maybe I was colorblind that day, sections 9,000 to 9566. All right. Well, that's all pretty, but what is it? How does it work for you? I have in my, let me see if we can get there. I have in my links, see if I can show you how to get to the Civil Code. Now I've got a link in my Explorer that goes directly to the California Civil Code. Usually it comes up faster than that, but here we go. Okay, so this is the California law. And everybody on this call can go there and look at the statutes. It's pretty easy. Now I'm going to click on the Civil Code. I'm not going to put in any search terms and just hit search. And there you go to the table of contents for the entire Civil Code. Now what I'm going to do is hit Control-N, and we're going to go to the very bottom. And now you see Division 4, Part 2, let's go. Works of improvement generally. Here's Part 6, Works of Improvement. And so those sections that I just showed you highlighted in color are now here. And what's so nice about what they did, actually they did make it more accessible to people, is if you have questions about a mechanic's lien or a stop notice, you can generally find it through this index. Okay, I want to know generally about stop payment notices, and there you go. Click on 8500, and you get the sections that deal with stop notices generally. It's a quick read. It's easy to find. And so if you have questions that you want to try to answer yourself, I submit that it's a pretty easy way to do it, is just going directly to the lien law section in the Civil Code itself. Pretty easy. Took us under 2 minutes to do that. Okay, still in the general changes, one of the things they wanted to do was clarify some of the language, and there's some helpful things in here. Why they wanted to fool with a 20-day preliminary notice, I have no idea, but they did. Instead of a 20-day preliminary notice, it's now called a preliminary notice. Does the 20-day change? No. You still have to serve it 20 days after the beginning of work to capture all of your work in a lien. Why they changed that name, I don't know. I guess it's simpler. They saved 1, 2, 3, 6 characters. And if we can wake up my, hello. Okay. Looks like we might have frozen up here. Sorry about that. There we go. Okay. Material man, I guess we need to be PC, is now material supplier. Significant change, and I don't know. You be the judge on that. Original contractor is now called the direct contractor. Now, actually, this one makes sense. And what they did is they're doing, instead of talking chronologically, who's the original contractor versus a later contractor, is now talking in terms of relationship. Is someone who is a direct contractor is in direct contract with the owner. And so there is generally only one, and that's the general contractor. And so that is a helpful change. When you see direct contractor, you know that that means that person has a contract with the owner. Stop notice is now a stop payment notice. Now this also is to me, a helpful change because there's more than one type of stop notice. There's also a stop work notice, which has been called a stop notice. And so now they call this one a stop payment notice, clarifies that you're not talking about stopping the work, but talking about stopping payment to the general contractor. If you're a subcontractor, you cause the owner or lender to stop paying to the general to hold funds, which now become a security fund for you, the subcontractor, so that the general won't dissipate the cash to somebody else or himself. So it's a stop payment notice. Contractor, unfortunately, this is one of the confusing things, is that contractor is a general term and will include subcontractor depending on the context. And so when you see the word contractor just in itself, you don't know if that means the general or the sub or a sub-tier subcontractor. It could be any one depending on the context. All right, now we're going to talk about the forms and the changes in regard to the project stages. So we know that projects start with generally the signing of a contract. We do a lot of pre-work to get ready, but the contract signing is actually the start of the contract. And so then the work progresses, and there's forms that deal with payment issues during the progress of the work. Then there's completion. Sometimes there's claims, and then you have to perfect your claim if you're going to proceed and prevail on your claim. So this is generally the payment issue cycle on a contract. I guess this program doesn't like it when I use that little highlighter, so I'm going to stick with the pointer. I hope you can see the pointer. If not, I can. Anyway, so we'll go contract signing. Now, what forms are used at the different project stages? There's, at the time of signing is the preliminary notice. Remember, it's not any longer the pre-20 or the 20-day preliminary notice. It's the preliminary notice. That's both on public works and private works. And then when the work is ongoing, as regards payment issues, we have conditional and unconditional lien releases. That's the same. By the way, the preliminary lien notice has changed, as has the conditional and unconditional lien release upon progress and upon final payment. Those are new forms. We'll go through those in a minute. Now, when you get to completion, there's notice of completion form, a notice of cessation form, and notice of acceptance. Used to be there could be notice of acceptance on private works, but not anymore. That used to be a form of completion, but no longer. You now have that only in public works. And in your packet, there's notices of completion and cessation. By the way, the notice of completion form we have is generic. It goes for public or private. In case you're wondering how come you don't see two notice of completion forms. Now we get to a claim. You have your lien claim. That's on private works only. No liens on public property. You can't foreclose on a courthouse building. That would be interesting. Can't steal the public property or take the public property for your private use by virtue of foreclosing on a lien. You can do stop notices on public and private, and then also make payment bond claims. Typically, there's only a payment bond on public projects, but sometimes on private. And then to perfect the claim, if we run out of time and we get going too long today, which I think we will, we probably won't be talking much about perfecting the claim because that's really your lawyer's issue. Once you've made your claim, you've recorded your lien or issued your stop notice, payment bond, you've got to give those papers to your lawyer as soon as you can, and then he or she will calendar the time to perfect the claim by filing a lien, a legal action to foreclose on the lien, for example. And your counsel should record and serve notice of the claim, notice of the action, and list, or otherwise known as the list pendants on your behalf. So if we run out of time, we'll expect your lawyers will know this stuff, and so you won't have to worry about it. Preliminary notice. The purpose of the preliminary notice is to inform owners, lenders, contractors of whatever tier that you have a potential lien or stop notice, or a potential for issuing a lien or a stop notice. Here's my little jazz bugler. I wanted him to be able to blow an announcement, but couldn't find just a plain bugler, so we got a little jazzy here. But anyway, it's to give notice. Da-da-da, there's potential for a lien. Now, the same, you got to serve your preliminary notice within 20 days of the first labor or materials. Now, I'll say the best practice is just do it immediately. Once the contract is signed, boom, get out your preliminary notice. You don't have to worry about it. You don't have to count the days. You don't have to think, well, when are we mobilizing or delivering materials, and then calculate from that. Just take the issue off the table by immediately. Just make it part of your program and your procedures in your office. Contract signed, boom, preliminary notice out the door. This is a change that somebody says this is change, but I have fuzziness in my head about whether or not it is actually a change. But the point being that you do your preliminary notice based on the contract that you signed. If you signed 3 contracts on one project, you need 3 preliminary notices, even though the players on all the contracts may be the same. They need to have notice under each contract, and it's not per project. That could be a trap for the unwary. But it goes back to once you sign that contract, boom, send the notice. New signature, new notice. End of story. No question. Now there's a specific new form that went into effect July 1, and let's see if we can find that one. This is the unfortunate, unwieldy part of this seminar, because normally I would have a handout of binders and we could just reference a page and everybody could talk about the same page number. But here you go, California Preliminary Notice, Private Work. It's essentially the same for public, except for there's new notice language that has to be given to the owner of the property. Basically, to prevent the owner from having heartburn or palpitations upon receiving such a formal-looking notice document. By the way, yours will look a little different, with the formatting, but I just put it into a bigger form just to make it easier for discussion purposes. So the fact that this one looks different than what you may have on your desk, don't worry about it. It's the same form. So this language just explains to the owner that, hey, this doesn't mean anything other than it's putting you on notice that there's somebody that may have a claim against your property later if they don't get paid. So be aware that this person is out there, they're working on your project, and if they don't get paid, they may exert lien rights onto your property. So that's new notice. This language here, notice property owner, is statutorily required. It was changed in the middle part of last year from an earlier version, and this is updated again. Rely on the forms but make sure that you have the current forms. And your lawyers should be, if there's a change in the forms, they should be notifying you when the change happens. If you're a Law Notes subscriber to McLennan Law Corporation Law Notes, you will get those updates as they occur. I put this language in there just telling the owner, it's not a lien, don't worry. This notice is required under California law. So don't freak out, don't have a heart attack. It's not, it's just a notice. Okay, let's go back to our slide, see if we can do that. Hey, all right. New notice, private works only. The public works form doesn't have this notice property owner because they're a public entity and they should be more sophisticated. And then there's new service requirements on how to serve your preliminary notice. Actually, it should be easier than in the olden days because there's more options. Now, there's specific people that you have to send the preliminary notice to. This is a change. It's not a change. There's one change that we'll get to in just a second, but this is, you know, if you're a sub or a supplier and you're sending materials and labor to the project, you want to let the owner know that you're out there and that you may have a lien claim, so you send it to them. The lender, usually there's only a lender on private works, but as we see PPPs coming along, there may be lenders involved in public-private partnerships, and so this is good to know. Just be aware. You want to check the title and make sure that you pick up all the lenders. Must be identified in direct and subcontracts. So your general contractor should tell you that if you, in your form subcontract, who the lender is, but it's not healthy to rely on the general contractor, because if he gets it wrong, you may still lose your rights as against the lender, because the lender will say, well, we didn't get notice, and therefore our lien has priority and you're out of luck. So the best thing you could do, and should make a note here, standard operating procedure on any project where you want to give yourself some security that you're going to be paid via a lien, and you want to make sure that you identify the lender. And you can verify that by getting a relationship with a title company. I have a long-standing relationship with Chicago Title Company, and anytime I need to check on a property to see if there's any liens out there or a lender out there, I can go online, do a property profile, pick up any lenders, and then give them notice or whatever, but I'll have that information. And most title companies will set up something like that. It's free of charge, it's easy, and there's really no excuse for any one of you out there to not have a firm verification of who the lenders are. If there's a new lender that comes on, say takes out a primary lender, or they run out of money from the first lender and need more construction funds, the owner should give that information to the direct contractor and to anybody who served a preliminary notice. So if there's a change in lender during the course of construction, you're supposed to be told about it. And actually, the good news is that your lien should have priority over any later lenders. But again, if you get notice of a new lender, you'll want to send them a copy of the original preliminary notice to make sure that they know that you're out there. You can't rely on the owner or the direct contractor to have given that information. Subs and suppliers, if you're in direct contract with the direct contractor, you don't need to give them notice because they know that you're out there, but you should if you're a lower tier subcontractor. And anyway, why cut corners? You know who the direct contractor is. Give them the preliminary notice, and anybody who's up the chain, you'll want to give them the preliminary notice as well. to avoid any potential problems. This is a big deal, and you want everybody and his brother related to that project to know that you're out there. Okay, the direct contractor must send it to the lender. What this means is the direct contractor himself must issue a preliminary notice to a lender, or else he loses lien rights. And that, there was an ambiguity in the old law, at least it was ambiguous to one contractor who provided trees to a project that failed, about $3 million worth of trees, and he failed to give notice to the lender saying, well, I'm a direct contractor and I don't have to give you notice, and the Court of Appeal disagreed and said, yeah, you should have, and your lien is invalid as against that lender who foreclosed on the property. So it's a big deal, and you want to make sure that the lender gets notice that you're out there. Public entity, that's who gets it. Now, service on the surety is not required, but I'm going to tell you that since you're just filling in boxes on this form, why not fill in one extra box and give notice to the surety? Yeah, it takes an extra stamp and an envelope, but it's a good practice because then the surety knows you're out there, and then if a payment issue comes up and you write a letter to the surety to say, hey, we're going to have to make a bond claim if your guy doesn't straighten up and make payments, they'll know when they get that letter that you're legit, you're out there, and then they can put pressure, the surety can put pressure on the contractor above you to make the payment. So the fact that you gave them notice can be helpful down the road, even though it's not required. Proof of service is simplified and put all into one section now. 8118 gives you the specific requirements. Now, there's a sample affidavit form, and the idea is that you can use the same proof of service declaration for any of the notice or lien forms that you're going to be serving on any project. So basically, here's the form, proof of notice declaration general. You could put in the name of the document, put in the method of service, who got served, and sign it. It has to be under penalty of perjury that the service was made in this way. And then I give you at the bottom of the form section 118 because it tells you what documentation you want to keep with the proof of notice declaration. You're not going to serve the proof along with the document that you're serving because the proof doesn't exist at the time that you send the document, but as soon as the proof of the service exists, that is, you get the return receipt returned, or you get a declaration from your process server, you staple it to the proof of notice declaration, which is itself stapled to the document that you've identified as being served. You keep it in the file together, and then when an issue comes up, and these issues come up all the time because lawyers in the construction field like to pick apart notices and service, and so the issues are going to come up, and you want to make sure that your file is pristine, that it's complete, that it has all of the proof of service information right there at your fingertips so that you can tell the other side's lawyer to forget it, that he's not going to find any holes in your process and your service. There's methods of service authorized under the statute by personal delivery, which is always the best. Certified mail is a problem, or registered mail can be a problem because you don't get the certificates back, right? People will just ignore them and not pick it up. We see that all the time. So what we do is if you serve certified mail, you get the envelope comes back because it hasn't been claimed. You keep that envelope in your file, but also you serve at the same time first-class mail because that will be delivered without a signature, and that way you'll know that at least the person that you want to give notice will have gotten it, even though you don't have acknowledgement from them that they got it. but at least you can say to the judge later, look, we got the envelope back. We figured this guy wasn't going to accept service of it, so we also sent it to him first-class mail, and that letter didn't come back, lo and behold. So, Judge, it's pretty sure that he got it. If you really want to make sure that somebody got delivery of a document, though, personal delivery with a declaration by the process server or the person that delivered it is the best way to go. Express mail and overnight delivery are handy too. FedEx, you'll get a proof. Express mail, you get proof of service. So those are pretty handy. You got the problem that FedEx left it, but the guy that it's directed to says, well, I didn't get it. Somebody else in my office must have picked it up, or at this building must have picked it up. So you got a little bit of a hole there. So again, the best way is personal delivery, but the overnight delivery is pretty good too. And so I just in this form, check a box, how you're going to do it. You know, pretty easy, straightforward. Just slap that onto the back of your document. Addresses for service of notices. This is in the statute. We don't really need to go through this. Where to serve it, there's lots of different possibilities. But whatever it is, if you have any question about what address to use, it's easy to find 8108 and check out the authorized methods. Proof of service. Again, addresses where to send the lender or the direct contractor or subcontractor. These are all in the statute. It's always good to use the CSLB address because, as you know, contractors are required to keep this Contractor State Licensing Board up to date on your address at all times. If to the claimant, if notice is being given to a claimant, whoever that claimant is, whatever their address info from whatever source on the project. Again, CSLB address is always good. Surety, there's an address on the bond, or you can serve on the Department of Insurance. Okay, lien release forms. Everybody, you deal with these day in and day out. Those forms changed effective July 1, 2012. I'm still getting calls from clients saying, this general contractor requires that I use their old form. They won't accept the fact that the forms changed in July of this year. And my response to them is, okay, fine. If they want to have you use the old form, go for it. Because if that form proves to be ineffective now because it's the old form and not the new form that came into effect, that's the problem for the general contractor, not you, because in effect, if it's unenforceable and because it's the old form, that means that your lien rights are not waived, and so good for you. Let's take a look at the new form of lien release, conditional waiver on final. Let's find a conditional on progress. There we go. This form by the commission basically said, look, we are not trying to change the form and the information required to release liens, but they did add language and potentially did change the enforceability of the lien forms. So you have, and by the way, this form that you see here is exactly the wording that's in the statute. I cut and pasted out of the statute and just reproduced it here. So no pride of authorship for me on this one. The key is these forms have been criticized because it creates so many exceptions, and basically, essentially, in some people's eyes, it's worthless because it doesn't release anything that's a claim or a breach of contract or exceptions as noted for retentions, extras, for progress payments that haven't actually been receive payment on. Well, what if your general contractor's gotten behind and you've got 5 outstanding progress payments where you issued conditional waiver releases? Do you have to fill them in on these boxes right here on this form? Not necessarily in these boxes. You could just say, please see attachment. If you have a printout from your billing software that lists the date of the conditional waiver and the amount and the through date, you could just say, please see attachment, and then attach it to the back. That makes it easier than typing it into the form. But some way, somehow, you need to make sure that each of your conditional waivers, and same with your unconditionals, lists any unpaid pay application, because inadvertently failing to list it could mean that you do waive something that isn't specifically set forth. So to my mind, these waivers do have some impact, but it is limited by making express all of these different exceptions. These were, by the way, exceptions anyway, but now they're just incorporated into the form. And so hopefully for us subcontractors, it's much harder to blow it because you're reminded every time you complete one of these conditional waivers to make sure that you're complete. Now, this one is a significant a change for subcontractors. There's case law in California that, let me back up. On final payments for retention, the law was clear that attorney's fees would be awarded on, if you had to sue and recover your retention, you would get to recover your attorney's fees. The law was not so clear with regard to progress payments. We've made the argument that the attorney's fees award did apply to progress payments and were successful in convincing a trial judge at one point. However, and there's case law in the courts of appeal that go that way, but there's also cases that say the opposite. And so there was some uncertainty. This is one substantive change that the Legislative Commission did make, and say, we're not changing the law, and we're saying the law was that attorney fees are expressly awarded if you have to sue and recover a progress payment. So that's good news for subcontractors, which segues actually into another issue, is whether or not you put attorney fees clauses or allow attorney fees clauses to exist in your subcontract form. My base position on that is attorney fees clauses make parties stupid. And you get aggressive lawyers for the other side who beat their chest and say, we're going to get our attorney's fees, and we've got a case right now, $33,000 at issue, and the other side will not mediate with us because they say they're going to get their attorney's fees. I believe they're wrong, but they don't, and so it's making it exceptionally difficult to settle the case. So just as an aside here, especially since you have in the law right to recover for your attorney's fees on progress payments and retention payments if you have to sue to get those payments, since it's already in your favor in the law anyway, why stick it into the attorney or into the contract, which may cause you to have exposure for the general contractors or others' attorney's fees on other issues than just payment. For example, if they sue on a defect claim, do you really want to give somebody attorney's fees for suing you for defects? So anyway, enough on that. I'd say strike attorney fees clauses when you can because you got it in the statute. Lien releases, final payments, similar changes. Let's see, we find conditional waiver on final. Same thing. You've got what it does waive, what it doesn't. Again, even on a final payment, the conditional has exceptions. if you have a dispute about extras, and by the way, if you have a dispute about other items that are disputed, such as if it may not be extra or you think it's extra, the general doesn't, say disputed withhold on the payment application number 5 also. Make sure that you put your carve-outs into these waiver forms so that you don't inadvertently waive something that an amount or a payment request that you've been negotiating over up to that point. Okay, what is completion? There's forms for completion or cessation. Excuse me. What is completion? There's a statutory definition, which actually has changed a little bit, but it's actual completion of the work. Well, how do you know that it's done? Well, you don't go back anymore because all the work is done and the owner is using it. So actual completion of the work is completion. Occupation or use by the owner accompanied by cessation of labor. So the owner moves in and they say, you're done, we don't want you to come back out anymore. Or the general says, don't come out. General says, we're not coming out. After a period of time, that devolves or becomes a completion. And cessation of labor for a continuous period of 60 days is a completion. Well, why do we care about completion? Well, because that impacts when your lien claim or last day for stop notice and bond claims must be recorded or served. Cessation of labor for 60 days is a completion. So if you want to halt the time period and reset it, if there's work under your contract that you can still do, you've been off the job, general says, I'm not paying you to come back out, but you go out and install a new handrail or something like that, that will serve to start the clock over again. So you do have some control whether or not the time is ticking. Why would you do that? Well, because you're negotiating over a payment, it's not done, and you don't want to file your lawsuit or serve a stop notice, and so you can buy time by just going out there doing a little bit extra labor, putting in some more material. Now, acceptance of projects is only available anymore under for public works after July 1. Notice of completion. Here's the impact of what these notices of completion, what difference it makes. And we do have a...
Dan?
Yes.
There is a question.
Oh, I'm sorry.
It's okay. There is a question on how does an outstanding punch list affect the definition of completion?
Good. You know what? I don't see that question. But anyway, how does an outstanding punch list affect the completion? Now, there's old case law, and this has been developed pretty rigorously in the cases where a punch list was issued, but a subcontractor went back out to the site to install soap dispensers. And that, up until the soap dispensers were installed, the project was not complete. So since the contractor put in new material, then it wasn't complete, and so the punch list item excuse me, extended the time for recording the mechanics lien. Now, if it's just pure punch list where it's, say that you have to adjust an HVAC system or the hinges on a door, make sure the closing mechanisms are right, the fit and finish is right. If it's no new materials being installed, then completion could have happened even though you were out there working on the job. So thanks for that question, and I'm sorry I didn't see it. Let me see here over. Yeah, I'm not seeing any questions coming up for some odd reason, but sorry about that. So hopefully I'll get noticed by Virginia there. Anyway, okay, here's the notice of completion form. Pretty straightforward. What you're going to find is on all of these forms, you have to have a, well, probably this isn't the best form to look at as far as the consistency, but you need to identify the property by reasonably so that the recorder of the county real property records can put it into the right APN file. So you want to give the legal description with an APN if possible and a street address. And you could say, if you don't have those, you could say, well, it's a project at the corner of 5th and A Street in San Francisco County, San Francisco, whatever. And then the recorder can locate the file to put it in. But this notice of completion, you see the civil code section, the 8000 series, and then, the 9000. That tells you that this applies in public works as well. Who's the owner? What type of owner is it? Do you know? If you don't know, if you think that they're a partial owner but they're actually 100% owner or vice versa, if you get that wrong, is that going to invalidate the notice of completion? No. Do you, by the way, do you issue the notice of completion? Generally not. Why? Because you don't want the notice to issue, because that trims down how much time you have to record your lien. And so what we do is when we see notices of completion, they can either be too early or they can be too late. And if they're too early or too late, they can be invalidated, which means that you'll have more time to record your lien. So your lawyers are always going to be looking at the facts underlying a notice of completion and the timing of the service and filing of the notice of completion. Since it's going in the real property records, they should be notarized, and even the owners, or typically it's the owner, it could be a general contractor who wants to keep control of that and make sure that his subcontractors get timely liens to him so he can deal with them before and not have his final payment be held up. So the general could, or the direct contractor could serve the notice of completion also. And so they'll have the mailing affidavit with all the names on it of the people and how they got served.
Dan?
Yes.
There's another question.
Okay, thank you.
And it says that if I have unpaid balances on previous progress billings,
yes.
should I add this amount to the final invoice amount when I fill out a conditional final release?
Yes. What do you do with those prior unpaid balances? Well, what you do is let's go to the form. This will be the conditional on final. Let's do the conditional on progress. Conditional on progress. Okay, so what we have is the through date. And so this, the work has been done through, say, the end of November of 2012. And so you're dealing with all the work and payments up until that time. So the amount of the check that you're expecting, and you may not actually have the check. We've seen conditional waiver and release forms be executed before the check is issued. Then when the check issues and we get it and the check is cashed, then it becomes an actual waiver. And that's okay. But so the date of the check and the maker of the check, you may not have a date of a check because you don't have a check in hand. The maker is going to be the company that pays. The payee on the check is you. And then the amount of the check is just the amount of this payment application, not the total to date. Because what you're going to do is you're going to have itemized down below in the exceptions the payment applications with their individual amounts. So the answer is yes, you do have the total amount of all prior payment applications in the form, but not in the amount of the check that you're expecting for this particular progress payment, because if you do, then you will be duplicating. And we've seen that happen, actually, where the subcontractor used the amount of this check, the cumulative of the exception items down below, and when they issued, the payor, general contractor, issued the check relying on this payment application, and then later they backsold and paid some of the others, there were a duplicate payment, which actually confused the accounting quite a bit, and we're still having to sort that out on one project. So the amount in the check is only for this payment application, because you're going to itemize all the prior unpaid applications below. I hope that answers the question. Okay, so back to completion, notice of completion. Now, your normal time for recording a lien is 90 days after the project is complete. And there can be some fuzziness, as we talked about, as to when is the project complete. And it's not your work. It's not a subcontractor's work that's complete. It's 90 days from the whole project. So if you're an early finishing trade, like a concrete foundation guy, you could have a right to lien the job for 90 days after the whole job is done. It could be a year after you're off the job, and you still have lien rights because the whole project hasn't been done. That's the normal time. Now, the notice of completion is going to shorten that. So once the notice of completion is recorded and served, you've got 30 days from the date of recordation. So actually it may be 25 days because they record it, they mail it, you don't get it for 5 days. But anyway, it gives you notice that, hey, you've got to jump on this and make sure that you record your lien fast, otherwise you're going to lose your lien rights. So it's 30 days for a sub or a supplier. Now, how do they know who to give that notice to? Well, they got preliminary lien notice from you, and so they'll send that notice of completion to all people that they have preliminary lien notices from. If you don't have a preliminary lien notice, you're not going to get notice of completion, but you're not going to have any lien rights anyway because you waived it by failing to give the preliminary lien notice. So those preliminary lien notices are exceptionally critical to your lien rights. Then the direct contractor has 60 days after recordation of the date of the notice of completion to bring his lien. So 30 days for the subs, then the general has 60 days. Why? Because after that 30 days, he's going to know who all the subs are, and then if liens are filed, he'll know how much to include in his lien or not, because he's got that extra time. And he can hopefully deal with subcontractors' liens and get them out of the way so that he can lien himself for the whole amount or avoid some complications for the subcontractors having to sue. But it gives him time, that extra 30 days or so, to deal with it. Okay, the owner must record the notice of completion or cessation within 15 days after completion. It used to be 10 days. Why they expanded it, I have no idea. But, just one little picky change in the rules. It's got to be signed and verified, served on the general and all subs that serve their preliminary lien notice. We talked about that.
Dan?
Yes.
The original person that was asking the question regarding, she says that she was asking a question about a conditional final release.
Oh, conditional final, okay.
Should she add the unpaid previous balances on the final release?
Let's look at that.
Or should she add the unpaid balance on the previous progress invoices to the conditional final release?
Okay, now that, okay, on the final, yes, this one should be the total outstanding balance, because you need to be paid that total outstanding balance before you waive your lien rights. Now again, the exception for the conditional and the unconditional is not going to have this. Let me get that conditional, the unconditional final, so we can compare. Okay, there's the unconditional final. Well, you have the same exception under both. The conditional final and the unconditional final gives you an exception for disputed extras only. And so in concept, the only thing that's supposedly a dispute that's going to survive your final lien waiver is something for extra work. And so, again, what's extra and what's not, what was in the original scope, is often a part of the dispute. And so you'll have to identify when you write out your form why it's disputed and why you think that this item is not within the scope. But otherwise, the claimant has been paid in full is the final statement in the unconditional and the conditional. You'll be paid in full except for the exception. And the language is not parallel, but the concept's the same. So this amount of the check on the conditional final should be the total outstanding balance less the amount that's for change order work that you're claiming. And be clear that A plus B, the amount of this check and the extras will be the entire claim amount for your project. Let me know if we haven't nailed that question now. Okay, let's see. Going back, the owner with multiple prime contracts, there may say that the owner breaks up a project into a different contract for different buildings. There may be 10 different buildings, each with a separate prime contract, because they're fast-tracking it. And so the owner could issue a notice of completion on building 1 through 3, and then later on 3 through 6. And so the time to lien on building 1 through 3 could be running while you're still working on buildings 4 through 6. And so that gives the owner some ability to limit lien claims. Again, the notice of cessation must be served within 10 days of recordation. So you got 15 days. The owner has 15 days to record it, but then has to serve it within 10 days after it's being recorded. And again, your lawyers are going to pick apart these dates carefully to make sure that they've dotted their I's and crossed their T's to make it valid. Even if you think that your claim may be late, it's always best to just run down and record your notice of lien. If your time is expired, so be it, but at least if it isn't expired, you will have not lost anything by waiting. So you can avoid an inadvertent waiver by, as soon as you know that there's an issue about recording your lien, just get it on file. You can sort it out later. This is how the owner has to make its service. He has to use the certificate of mailing if he doesn't have the certified mail or registered mail reception. By the way, anybody out there working with homeowners, don't expect that you're going to get a notice of completion. They may, but they are not required to give you a notice of completion.
Dan?
Yes.
There is another question.
Okay.
Basically, it says, but if the concrete contractor has a direct contract, his work can be completed prior to the project completion?
Yes. And we see that all the time. fairly frequently, and that's a bummer for early finishing trades, is that what happens is that they'll complete their work, say the foundation, you're only there for the foundation and the podium, and your work is done within the first 4 months, and yet it takes another 2 years for the building on top of your podium to be completed. So it's a bummer because that concrete subcontractor ends up often waiting for the retention until the whole building's done. So they may be floating, say a couple $100,000 for a year or two after their work is done because the retention's not released until the whole building is done. And so what we do, we strive strenuously for subcontractors with early finishing, like the graders or the steel erectors or the concrete subs, for early retention release, that they would get their retention released within 60 days or 90 days after completion of their work. That gives the owner and the general contractor time enough to know if there's any problems in the work, and if it doesn't surface in that amount of time, then they should feel secure in releasing retention to the early finishing subcontractor. Okay, going on, we have recordation of notice of cessation. Now this, once you have notice of cessation, all the rules are the same following an initial 30-day period. Once labor has stopped for 30 days, then the subcontractor or the general contractor or owner can record a notice of cessation. And then all the other timelines kick in. It's got to be signed and verified, same. And by the way, we'll pass over a lot of this stuff, but the forms are pretty self-explanatory, and so you just follow the forms and you got it figured out. Now, the recording of the notice of cessation is same as notice of completion, 15 days and 10 days, and then they have the same effect. After that first 30 days, then the 30, 60, 90-day rules apply. So 30 days after work is stopped, then there's a notice of cessation. Then subcontractor, you've got to hustle because you've got 30 days to record your stop notice or serve your, record your lien, serve your stop notice. And then the general has the 60 days. Otherwise, if there is an invalid notice of cessation or notice of completion, or it wasn't done, then the 90-day rule applies for the general and the subs both to record their liens or serve their stop notices. Okay, there's that 90-day rule. Liens. Private works are the only place that you can get a lien. We talked about that briefly earlier. You can't foreclose on public property because that would deprive the public of the use of that public property. So it's constitutionally protected. Your lien is a big deal. And that actually helps give some play in the joints because it means that the courts are supposed to liberally construe your efforts to comply with the lien laws and not find waivers of your lien rights lightly. It's a constitutionally protected right you have to be paid. The real property on which you're working, other than public property, secures payment for your labor and materials. It's like a fund. Hopefully there's equity there. And it actually grabs a piece of the real property. It's like you've got a grappling hook that sinks its hooks into the real property, or you've got just a good firm grip on the real property where you can grab the property to get yourself paid. No liens on public property. We talked about that. You have to use the proper forms. Now, the law says that if you don't do this right, you can commit a waiver of your lien rights. And so you want to make sure that you use a current and up-to-date form. You have to give notice of the lien to the owner before you record it. Well, how long before? It doesn't say. So we will typically concurrently give the notice and do the recording even on the same day if we have to preserve lien rights. There's new design professional liens. We won't talk about that. I don't think we have any design professionals on the phone, but just know that they're out there. And design professional liens actually will convert into a mechanics lien, which actually may impact you because they will be grabbing the same security as you, and so may interfere with your right or defray, limit, reduce your amount of recovery if there's competing interest to the same lien fund that is generated from sale of the building or project. Timely is critical. These things, if you don't record it within 90 days or 30 days, as the case may be, it's waived, and it's a void lien, and so your right to that security is gone. And so care in calculating these dates is critical. That's why once you record a lien, make sure that you get those forms to your lawyer immediately so that you put your lawyer at risk for failing to calculate these times correctly. You want to let them worry about it, and they'll calendar it and make sure it gets done right. Notice of mechanics lien must be recorded. And by the way, that's in the form. I'll just show that to you real quick. Claim of lien. There you go. Here's the notice of mechanics lien. We just put it right in the claim form itself. Here's upon recording of the lien, basically your property is subject to being foreclosed on and sold to pay the lien. So that notice, this language is right out of the statute. It's cut and pasted. The statute tells you how you do it, so we just included it right there in the form. The language did change in January of this year, but the form that I've showed you here has the updated language in it. Oh, and there's the language right there. Lien form, put in your balance, due after all payments, credits, and offsets. It's a good faith testimony, good faith effort required. By the way, if you overstate it a little bit, we've got that issue in the office right now where is it a balance due? What does that mean? Is it immediately due or is it eventually due? Our client did a lien claim on the day after the last payment application issued and included the amount of the last payment application in the lien claim. Does that invalidate the lien claim because it's overstated because that payment wasn't due yet because the payment from the general contractor to the first-tier subcontractor hadn't been made? I don't think so. It's a good faith effort. It's really, if it's a willful overstating of the lien amount, then your lien will be invalidated. But if you give a good faith effort, it's fine. Point in fact is the amount was due. It just wasn't due immediately, and after 30 days passed when the due date for the payment came and went, then the balance was absolutely correct, due and owing as of that date, and so no harm, no foul. But you want to be careful with calculating the amount. Who gets the service? You have to put in the name and address of the owner or reputed owner if you don't know the owner. But again, make sure you get your title report. You'll get the owner's name. Unless there's some transfer that happened that wasn't recorded, then you'll be fine if you get the reputed owner.
Dan?
Yes.
There's a question regarding the forms.
Okay.
The question says, do any of the forms, for example, the waiver or claims, etc., need to have particular size margins or be of a minimum font?
Say that last part again.
if any of the forms have to have a particular size margin or a minimum font size.
Oh, okay. Good question. I don't think so. Like the formatting that you see here with the borders and the formatting that's on our mechanics lien claim, that's what I came up with. The only issue that there may be is that notice of mechanics lien. I know that in the home improvement contract laws area, they are very specific. You must use boldface and you must use 12-point. And I don't know the answer to that as far as the lien claim. I'd say I'm tempted to take a quick peek at the statute, but I think let's talk about that one offline. I'm confident that this lien form that we prepared will satisfy because I think we've got 12-point in there. And it's not going to be any greater than that. I know that. So good question. If you want to email me afterward, and I'll double check that so you can be doubly sure. I'm happy to do that. Okay, general statement of the labor. Does that have to be terribly detailed? No, it's just general information so that the person being liened knows who you are and what you are doing in general terms. You don't have to put down include your entire proposal and scope of work, but just in general terms. Again, the description of property has to be specific enough for the clerk. We get the street address. Legal description is always good. The APN is always helpful for the recorder clerk, and you'll get that APN off of the title search that you can do from a preliminary property profile. Will give you that. Signature and verification. We've had it where a lien claim was rejected by a clerk because it did not have a notary signature on it. If that happens to you, you don't have to verify with a notary. It's good practice, but if you don't, make sure that you get an affidavit of the person that tried to serve it and record it on that particular day, so that when if it becomes arguably tardy later because you went and had to get a notary and then get the clerk to accept it, the date that you tried to do the recordation will comply, will be upheld by the court. Clerks shouldn't reject it, but we've known clerks that, for whatever reason, have their own ideas of what they need to have in their records. Proof of service affidavit for the lien claim. Now this one is in section 8416. Remember, we had been talking about 8118 as the general service requirement. Now this one is specific, and it's a holdover. And the legal commission, the law revision commission, didn't pick up on this, that they have potentially inconsistent requirements. This one says service by certified or registered mail or by first-class mail is how to serve a lien. Well, okay, that's the old rule. When you send it to the owner, reputed owner, we talked about that. If you can't figure out who the owner is or serve them for some odd reason, it comes back unserved, then you can, as a sub, serve the construction lender or the original contractor instead. Okay, that's good. But what about 8106, which is incorporated in 8118, that allows personal delivery or express or overnight delivery service? 8416 doesn't mention those, and I think, personal delivery is always going to be better, and why wouldn't you be allowed to serve your lien personally? I think that's just an oversight in the rule, and we'll have to clean that up. But you may be actually taking a risk of having your lien not be considered properly served if you use personal as opposed to first class. There's another way to serve by, like a summons and complaint. I don't even put that on the form because I don't want people to be confused with it. Service of summons and complaint confuses lawyers, and why the Law Revision Committee or Commission would put that in there, I don't know. I've left it off. If a lien needs to be served by your lawyer, he can do the summons and complaint, but why would you do that? Because if mailing by regular mail is sufficient, then why make it more complicated, like serving a summons and complaint? So it's there. I'd say it's better off not being used. Okay, there's specific forms for removing liens. Say that you recorded a lien and you got paid in part. You could go ahead and remove part of it using the lien release form. Yeah, this is a problem for subcontractors where if you have recorded a lien but you fail to remove it when you should, for example, if your lien was untimely when filed, or if your lien was not sued upon, you didn't perfect it by filing a legal action within the 90 days and it went stale, then the owner can bring an action to remove your lien called expunge your lien. And it used to be where the owner would, his attorney's fees would be capped at $2,000, no more. And so and they don't care to be efficient, owners, lawyers, and so they could end up charging $10,000 or $15,000 to make a motion to remove a lien, and you could be responsible for that under the statute. So it's a big deal for subcontractors if you let your lien get stale and you get a letter from the owner's lawyer saying get rid of it. Make sure that you handle that expeditiously so that you don't end up paying the lawyer's overinflated attorney's fees, the owner's attorney's inflated fees. Okay, stop notice. A stop is now a stop payment notice. Basically is a notice to the lender or to the owner to say, don't pay the general, hold those funds, he's not paying me, I need you to set those funds aside so that when I prove that I'm entitled to them, I will get paid from those funds. The stop notice grabs the money, not the land. Now this is important because stop notice is, you know that the money's there. It hasn't been paid yet to the general contractor. It's sequestered and set aside. This is important, especially in days, I think the real estate market's starting to come back, but in a couple of years ago when the real estate market was at a trough, there were a lot of projects that were negative equity, and so what, your lien was basically worthless anyway. And so it needed, the recovery had to happen on the prices for real property to give equity in a project so that your lien would have any value. But even while you may not have value in your lien rights, as long as the construction funds are all not paid out, then there's some money there to ensure that you get paid. So stop notice and liens are belts and suspenders, and you may have better protection under one than another depending on the circumstances. So stop notices are a good thing for subcontractors. There's details on how to do it, what you should put in there, general description of the work, same as your lien, total amount of the value of the work, how much has been paid for the work, the amount due through the date of the notice. Again, you don't want to overclaim willfully because that will forfeit your stop notice right. And even though you have a balance of $300,000 on the contract for work that's going to be done in the future, you don't put that amount in your stop notice claim. It's only in the amount due, again, is that immediately due? But no, the amount due for the value of the work that you did through the date of the notice is the essence of it. Must be signed and verified. This is served. It doesn't go into the real property records. It's got to be served before the time recording of lien expires. So the same time frames as we talked about, 30, 60, 90. You can serve the owner or the architect to get notice to the owner. You do need to serve the stop notice on the lender. After all, they've got the cash, so you want to tell them to hold off, don't pay that general contractor. So serve the manager or responsible person at the branch holding the construction funds. Get down to the nitty-gritty of where the funds are. Now, in private works, to make sure to force the lender to withhold, you have to give a bond with a stop notice. And that basically protects the lender from its costs if your stop notice was ineffective or improper for some reason. Then the lender will have some funds from you to protect its pocketbook against a bad claim by you. So that's in private works only. That forces the lender to withhold. Otherwise, the lender doesn't have to. They could ignore the unbonded stop payment notice. It's different in private works because you don't have to issue a bond. It's just automatic. A public entity has to hold those funds for you. Owner or lender may ignore stop notice if a payment bond is recorded. So if there's a payment bond on the property that's recorded, you get notice of it through your property profile, then you've got funds there in the form of the payment bond, and so the stop notice is not your first line of protection, but the payment bond is, so you'll make your bond claim instead. By the way, if the owner writes to you and says, get rid of that stop notice, we need you to issue let's see. Oh, no, I'm sorry. They'll say, get rid of that lien. We need you to serve a stop notice instead. If you don't, then remove the lien and issue the stop notice, then you waived your rights. So any letter from the owner talking about your stop notice or your lien, you'll have to take very seriously because it could work a waiver. If you sue on a bonded stop notice, you get your attorney's fees. That's in private only, not in public works. If you issue a stop notice, you don't get your attorney's fees. Sorry about that. Now, a stop notice is not affected by a foreclosure. So if the bank ahead of you liens the job, but they're holding, and they foreclosed on the job, but they're holding construction funds that haven't been yet dispersed, you may have a claim to those construction funds, whereas you've been nixed out because your lien has been foreclosed by the general contractor, or excuse me, by the lender. So stop notices are doubly good for that reason. Okay, public notice, served not recorded. Okay. Same stuff, 30, 60, 90 days. Stop notice to the public entity. By the way, if you write a letter and give them $10, they're supposed to send you notice if of your time to file an action to enforce your stop notice. That is, when the work is completed or notice of completion, then the public entity is supposed to send you a copy of that. But again, are we going to rely on a public entity? No, you're going to want to make sure that you monitor these timelines on yourself, by yourself. Okay, stop notice release forms, bond claims. We've gone an hour and a half, and I'm going to let you go here. There's a whole section here on bond claims and how you make them and what their amount should be, etc. Let me just finish with one note about bond claims, is that even though you didn't, if you subcontractor failed to give your preliminary lien notice, and you're a second tier or a third tier subcontractor, you may still have bond claim rights if the general contractor hasn't made his payment to the first tier subcontractor. But if he has made the payment to the first tier subcontractor, then your bond rights are gone. And you'll have 75 days after completion, if there's no notice of completion, in which to make your bond claim. So this is a little safety valve for subcontractors who have failed to issue a preliminary lien notice. So all may not be lost. However, a general contractor, if he doesn't have notice that you're out there and he, in good faith, makes a payment to a first-tier contractor and that guy disappears with your money, you're going to be out of luck. But if the general contractor, for some reason, has held up the cash and not paid the higher tier subcontractor, then you may still have some life on that bond claim. So it's just something to be aware of. Don't necessarily think all is lost if your paperwork's not proper. Okay, so that's probably a good time to stop. We've gotten to perfecting a claim. That's for your lawyers. As long as you've given your lien and your stop notice and your bond claim info to your lawyer, then he'll do what needs to happen, or she'll do what needs to happen to perfect the lien claim. There has to be a lawsuit within 90 days, otherwise it's going to be waived again. Okay, any last questions before we sign off? Again, let me say that if there's any questions, I'm happy to talk offline. You've got my email. You should have it in the slide deck that was given to you earlier. You've got it on all the materials. So with that, we'll sign off. If there's any last questions, let me know.
Dan, thank you so much. I don't see any other questions right now. I am going to allow the attendees to ask questions live if they have any.
Oh, great. Sure.
If not, we will be signing off.
Okay.
Hold on one second. There we go. Let's see. Okay. They are not. Are there any additional questions that anybody would like? I'm having a little bit of technical problems of muting everybody, but if you can type them up, I can ask them of Dan. We're just waiting for a second. Do you have any?
Also, just want to remind everybody that to please visit asaonline.com, register for an event. That's where we post the announcements of webinars like this in this series. So please stay tuned for future ASA webinars by visiting asaonline.com, register for an event.
All right, there seem to be no more questions. Oh, there is one more. And the question says, must you include the amount of the contract to make the prelim notice valid? GCs ask us not to. Dan? Dan?
Yes, thank you. I was muted there. I was talking away. Yes. I got the question. Thank you. Yes. General contractors they don't like it when subcontractors put their contract amount in the preliminary lien, preliminary notice, because then the owner and others know how much the contract is for, and so they can put a squeeze on the general for the profit and the markup that the general has over the subcontractor's amount. So the generals don't like it, and sometimes they'll put pressure on the subcontractor to not do that. But the the form, the problem is that if you don't put in the amount of the work, there's a chance that well, actually, the argument would be by the owner that, wait a minute, you didn't put us on notice of how much work you were doing. If you write in there the total estimated price of labor, services, equipment, and materials is $10,000, actually, or if you overstated it, either way, they'll say, well, wait a minute, that's not right. Your contract, in retrospect, they find out your contract was 10 times what you put in there, or vice versa, was half of what you put in there. Then they can say, well, wait a minute, this didn't give me valid notice of your lien, and therefore you shouldn't have the right to foreclose on our property. I haven't seen any case law that's invalidated a lien notice for that reason. So probably you're not going to have a problem. But why do you want to take that risk? You say, well, the code section requires that I put in the total estimated price of labor, and I've estimated it based on the contract amount, and so I need to put in the correct total. So I would say that I would push back pretty hard on that and say, look, I don't want to run the risk of invalidating my lien rights just because you don't want the owner to know what your margin is. Sorry, buddy, but why should I take that risk? It doesn't do me any good, and potentially creates serious problems for us. So I can't say that you will definitely lose if you don't put in the correct amount, but again, why take that risk? Any other questions?
There don't seem to be any more questions coming up.
Okay. Well, in that case, we'll bid adieu, and thank you all for being patient. We ran over by 10 minutes, but I hope it was worthwhile. And again, I'm always happy to talk about this stuff. It's what I do. So thanks, and have a great holiday, and look forward to webinaring again with you next year.
Thank you.
Okay. Thank you, David.
Thank you.
Okay. Bye-bye.